all day. Asempa FM. Ekosiisen ena wasugu so a otie no. Yada mu nyina asema mwakwa babie eba dwumadie. So ye to aso se de kan ahye mo no 6:30 p.m. and yade dwumadie eba awieye. And before see ebe kore ye ne lawyer Kojo Opon Kroma edi enkomo from the second petitioner from the second respondent and make a petitioner pal. Yebeshana fi yenya spokesperson from the petitioner John Dramani Mahama na yene won so edi nko. Let me remind you, so later on the show yebenya Dr. Bernardo Koboy e studio ha na yahwe COVID ene ehon sensem plus enra the former boss veterinary course so and issues a PPM ebaye and then a bit on the Supreme Court matters. Yebedi san komoni nyina ene area into monshan and so remember and it happens to be the birthday of a very special person to us here on Ekosiisen or your personal assistant Emma, and that's a special aid to the national youth organizer of the NPP Nidin the Kenneth Ofei Ansa ene na woda and happy birthday to you Ken. Live to be 94.7 and beyond. And unim Ken a friend na mana wodapa say chocolate be na wa top never check Kenneth Ofei Ansa, a very young man, quite dynamic, hardworking. Oboy Juma papa and man a boss Henry Nana Boache. In the Kenneth Ofei Ansa, happy birthday to you and live to be 94.7 and beyond. Kenneth Ofei Ansa. No, we are too much. Happy birthday. And Nana one in Kaswan so say Oma Awodapa a year Kenneth Ofei Ansa. And Nana one thank you. Okay, inti good fellow say better bitter chocolate nibi at the amount. And have a really good one. Ekosiisen suni a higher sempa inti say Obama so say he would want to wish you a happy birthday, Kenneth Ofei Ansa, and nipa bibina the messages eba to wish you and you have a good one, and we celebrate you on this special day. Ekosiisen suni Asempa FM. Enche yebeka homanzo ne lawyer Sammy Gyamfi'S asase edi enkomo, but Go Ahead Transport Enterprise, in fact maka won ho nsem akyerɛw aka omo boy juma papa na unim mumu bebre na ato cars ebia wo car no wo taxi driver bi awde amano se ontwi eya no waba be sales amount. But almost every day, sika awde bana nhyɛ da nkoye nti e kabubro na wobo. Unhyɛ da nya value, you know, from sika or the tour vehicle na na car no. Go Ahead Transport Enterprise aba ama say omo no de omo ye no say wo car na wato no wo de fabre won say monye me car na mfanya adwuma. At the end of every week mama me say, at the end of every month mama me say na wato mu ada. They would get that money for you. In the nya ne ye be frɛ na car no bumper ye we na tire pie na ye kwa kwasesa tire na nyina wo se ye tifiri wo sikam na no. Omo de ye adwuma na omo no etua o weekly or monthly returns. Profit ye de be ma na wotwi bia na wo pa ye betua bosomi bia na wo pa ye betua. Go Ahead Transport Enterprise de timi yes arenti wo de fa car no koma wo men how ho nkopɛ driver ne bibia sa dabi. They manage vehicles for individual car owners or companies who want to make weekly or monthly profit. Inti we a company a wan so work cars now person obi de car ne ye adwuma na otua wo car every month and every week. Go Ahead Transport Enterprise ebeye amount. Now, they also are into work and pay for ride hailing, that's Uber and a Bolt, etc. Omoye airport chauffeur, omoye door-to-door delivery of cleared goods from the port. Indeed, yeah, clear on yama every porter. Omoa betumi afa edi abreu bibia ubia door-to-door delivery of cleared goods from the port. The only one in come your office no of Fanco barrier mo amunim hono. Aso fan new station near Jojo Water and our Kenke house. Ubi hu yan office ho. O frɛ 0244 911 939 0244 911 939 and that's 0546 733 672 0546 733 672 na only into me any enkomo. Until let's get on to the phone lines now. Ne lawyer Sammy Gyamfi any enkomo ono kasa emma petitioner in the ongoing election petition case. Said ye munyina munnim no. Enti Sammy akwa ba na saying
Obi, me ho pa unyamedi ache.
Fantastic. Edi me o page see post away. The petitioner closed this case on the basis of the clear indication that Jean Mensah was going to testify. If despite filing a witness statement and what is in her affidavit, she now says she is not testifying, and the court says that's okay, then the petitioner is entirely within his right to ask the court for leave to reopen his case and use the subpoena route. In the way in some about what I find interesting, first sentence, no sir, mu close mu case on the basis of the clear indication that Jean Mensah was going to testify. Na more misreading of the law instead, more misunderstanding of what the rules of engagement are. And mu close mu case on that assumption, no, me pacho.
Oh, that be. Obi, sir, as a party in the case, you know, sir, you be two and a movie na you be na you be and krata at that court on the no. You don't see our copies. You're training in a munia what appears to be the indication from the other parties, in this case, the respondent, the first respondent. It is our say, yeah, some we call 9 courts. A new year, a free electoral commission over immense and Sasha say, so I crata the friend affidavit of verification a count on one and Sasha say. Na was also be heard court no ma order says the parties need be able to dance for so dance for no I was all my dance crata who bet another anymore omo de beto court in any no omo fa emra samre no I think 21st January na first respondent electoral commission am I who say obe dance ni ba kope. And that dancing, you know, electoral, Chief Mensah, the chairperson of the Electoral Commission. Ninti, almost file only one witness statement. Maybe Beatrice say, Emreno Edru na court on a cassette. Easy for me, Munkura, dancing, your mobile friend, Chief Mensah. Then, was answer Emra petitioner, no, through the lawyers. They are destroyed, they are court, and him said, Omo Emma Electoral Commission Emfa Nuye Emma
Ekosiisen
Sabe Idum Yunubia a friend interrogatory so no. So when someone Jimens and Ankaza Kanya I want the affidavits. So I cracked it was so I can say, oh, court. Then we say yeah, and this is will be saying here because me kotana kanimu as dancinia. Or move it to me to Toma, no maybe some same way in during cross examination. Then Odi and also Kraton chair. Okay, I say Mra, yeah, close to your case, a court, no. A fray, the first respondent, he said, almost on the coma, Omoka said, they don't intend to call any witness, so they were closing their case.
Yes.
And the president of the bench at the time, Justice Aniya Boaka, said, Omokrano, a fumo my surprise. And that is why at time lawyer Chachuchikata raised the objection. Omoka said they were not expecting that this would be coming from the first respondent. Inti Ebeya Young Komra Ochina on those issues. So even the court was surprised. Why were they surprised if they were not expecting Jimensa to be in the witness box. They were surprised because they knew, based on the witness statements and other indications from the first respondents, their witness, Jimensa, be mounted the box. That was the indication that, you walk court in the so even court no crack, I say, we the your mom wanti, your mom court, now China, your mom address you. So, and this in Kwan, or the petition on Kwana, he was taken by surprise because from the outset, the indication to everybody was that Jimensa was going to testify based on one kasa no numu asem. Say it's in bisebi ani ebisa na sambre no. Ehun hia na se oba adaka ni mu a ye pa ye betumi ebisa no. Now ye ka san sem bu na court no ede ni mu ayaba ne. Court no se one ye nya adwen. Wo court na adwen mu no. Easy for say omo na di omo ho. Omo mfre dansini bia. Omo mfre Jimensa e mani be dia dance. Witness statement na Jimensa de baye no kwa no omo mfo omo ho ntusu bie. Nti court no embu a ye ntumi nhye wo ana court ntumi nhye wo ta chenchenchen a Jimensa embra ye ne court no nya
Ekosiisen on Asempa FM
atemu ya court no di aba no mfonso bebre wo mu a ehun be hia se court no be hwe ni biem eno nti na ya lawyer for say omo the application of review akoto court na nim se court no ni diemu omo san so nwen sa decision no be no mo hwe se
review application no ma file and afi na mo be file
the information I have from my senior lawyer Duji who normally files this process has been filed.
The review, because what I've seen, the application to reopen the case.
Yes, the application to reopen, but and then notice was served. I have been informed by lead counsel that application of review will be filed.
Okay.
And maybe I don't know whether that has been filed as at now, but okay. I know it will be filed. Okay. That's the first thing. We disagree with the court, and your lawyers best study the ruling in detail and apply for the review of that decision. But even before court no day or more decision we airbano. Na your lawyer di kan court to say mpu court ne ka say isi when e di omo. Nti so mo omo free Jimensa as dancinia e omo amasem. I mean they are taking that risk. Nti they cannot compel them. Your other options are you be to me I explore. Okay, see this uncle when I visited the studio on Monday, and lawyer Chachuchi Kata Kwaso can once more court. And the option here clear said, Ube to me, as sans wako court and then need the Mnia Brasimu, wako court and they said, oh, my close to me case there, but when tea, Messer said, Ubama McQuain, Namasan so a BM case, na me to me,
Asempa FM,
I said, Jimensa said, Omrada come no media dance here. This time around, not for the EC. She's not coming as a witness for the EC, but she will be coming as a witness for the petitioner.
Yeah.
But she will be an adverse or a
hostile witness.
And he said, EC for one, your mom friend, man, be the dance here. Yeah, dear, you see a best friend. No, about be the dance here as an adverse and hostile witness. But you bet me, yes, sir, only if the court gives us the permission and a leave to reopen our case. And when he, yeah, this had to say they're not going to court anymore. Yeah, say court on the my da. Yemra make us asem. I don't know whether a return date has been given. I will have to check.
It's been given on the application for leave to reopen. 15th February and court 15th 15. That's Monday.
Ekosiisen
on the 17th.
On the 17th, which is Wednesday.
Yeah. So 15th before that, and then the court will determine. Say. Timmy, I justify why they must give us permission to reopen our case or intimidate. And I hope several reasons are a application for leave to reopen our case. I mean, any ubia where they are saying we say at least we have grounds to ask the court. So, and it is part of the rules of court. Na ye di obuni ni di amakot on na ye na ye ni se court ni gitu mu a obeba na ensem wa ye bebisa ne adanse oba bedi no ebeboa ma no kre ani atentre ne ayedwuma because ye de area no say about why you told 7th December 2020. The Ghana for Kanye and there was a boom and there was established at the end of all these proceedings. Not attend training the friend justice said. And when she say at the assembly if nipa bako which is a returning officer or nona yɛto abawie abana yɛto no kwa no na BBS ni na so a wɔyɛ ho adwuma nyinaa the 2020 presidential election ni sunsun so abato ni sunsun so ɔno na boy abato ni sunsun so ɛbɛyɛ mmra ɔno na ne nsa hyase abato ni sunsun so ɛbɛyɛ mmra yɛbɔ ho dawuru no saa dawubɔ no de friend gazette no so ɔno na ne nsa hyase enti sɛ chinyagye aba ho na abato ayɛto yɛ uti ɔno na numu asɛm a ya dream no mampenye kufu ado anwe ne wan cross the 50% threshold na wo de no so to nkyɛn a wo se wo yɛ mfonso da wo yɛ mfonso no bi anim mfonso kro no wo se wa correct so correction no yi nim bia yɛ correction ankasa because na waka we ɔkyena no waka we ɔkɔkɔta no waka we de bia wo de figure for ba ɛne yɛ ntumi nkɔka asɛm bi sei wɔ court abra nipa kora ɔyɛ saa nyɛma we nyina te ase na yakasa sa nipa kro no o ma daka ma yenti na no asem e wo so ba daka mu obekire sa nsem we mu nyina na Ghana fo nyina hwe bi tie no na court no so timi tie no na eboa ma court no etumi eteki a decision a be just and based on the truth now not just that
all those
obesa so ba daka no mu no say e be ma ye nyina ye hu say ba ye panyi mu na in this case Electoral Commission adwumayɛkɔ ehia paa wɔ yɛka ma menka bi mu de ba no dan ni ne
Ekosiisen on
so
Asempa
unimadwuma so ɔyɛ nokwafoɔ ana wɔnyɛ nokwafoɔ na abato nso so ɔde tu dwa on 9 December no na no krem no saa na tie ana nyɛ saa na tie obi eba ma obi ana wumi saa nyɛma ni nyinaa no free say court no ma yɛ kwan ne European case ne etimi ɛhyɛ ne sɛ wɔ mmra saa supina no ɛyɛ adwuma ɛbɛboa. And that is why we are going to explore that.
All these reasons, my lawyer Chachuchi Kata spoke for close to 1 hour 30 minutes. A canvassy reasons when you know, including the fact that or a constitutional officer now I was say or subjecting who to accountability. Ebe magana fu hu juma udi court ne say moba under Article 64(1), which is a very restrictive process. A chere bibi wasa oye. Sa argument of so a constitutional officer and it should be at a different forum. We know Article 64(1). There is no room.
It should be at a different forum.
Oh, now so the court made the point. Say you came under Article 64(1), which is a restrictive process.
No, so then seminar should be at a different forum.
In some say, or your constitutional officer court and they say it doesn't change the rules of engagement. The fact or your constitutional officer doesn't change the rules of engagement.
Court and they say young Kobe before for Kokasa seminar and not the any court and the kind. It be a case of 1 hour day of one issue. But Obi, let me just answer this question. The arguments for or the arguments against the EC4 decided say omoye no say ya na de ho yem fredance ni yem agreements am testify and yet the same as the arguments for an application for leave to reopen your case so that you can subpoena an important witness and yep so until court no bit me aka say ye ne mo nyadwen say yen share easy for such a or mon fredance ni but the betumi aba say court no be ya adwen say easy for na yentimi share omo e mo mon fregi mensa so mo dance ni dia oh ene petition na dia say ono no say ono pese of fregi mensa as dance ni a ye betumi ama na sa kwan so the two issues a subpoena and what the earlier objection and the arguments we made, no, they are materially different.
But the threshold of a subpoena, no cry, and no moment higher.
What's the threshold of a subpoena?
Because the point is, the court says the principle says a witness cannot be compelled to give evidence.
No, the court never said that.
Settled.
The court, no. You see, when you are quoting the court,
so
the court never said.
So what did the court say? What the court say?
The court said a party cannot be compelled to give evidence.
Absolutely.
From a witness cannot
a party, sorry, a party.
So a party, because we were compelling the electoral commission, the first respondent. And the first respondent is a party.
Yes.
And of course, and they say you cannot compel them to change now or media dance here. Or Fred dancing, media dance here, but Jean Mensah is not a party to this petition.
Yes, that's true.
She's not a party. Jean Mensah is a public officer, a holder of a public office, on the chairperson of the Electoral Commission and the returning officer for the 2020 presidential election. The chair which we can say, or on 2020 about why a 2 year man penny, no seen in Answa or ye who you mean. About one is why a boy on a year. This why I didn't say a man by around the year, they will go on the year. So, say, court to say, compel this person
on Asempa FM.
Now, on media dance here as a public officer, we are not compelling a party because Jean Mensah is not a party. Jean Mensah is a public office holder. So, Obi-Wan with the differences, you know.
Yeah, I've seen that difference.
Some media, Electoral Commission, a party, petitioner, or second respondent, Nanado don't go. So the court is saying that, for example, it means compel it. Nanado say, on Fred Anthony, Peter McMenu, because Nanado is a party to the suit, and or reserve the right to choose whether will be leading evidence to support the defense or not. Yeah, in the court, but that is the law now. Until that is changed, that is the law. But I am saying, say, the IPC, in this subpoena, no, and party to this petition, now we are looking at a public office holder, in this case, Jean Mensah, no only party to the petition. They say in the witness statement or the bias could be the dance one of the parties. Or no as a witness statement, on fine maybe. So she's also not a witness. So to that extent, she can be compelled, she can be subpoenaed. And even when you're subpoenaing a public officer, you don't need the course.
Ekosiisen on Asempa FM.
You know that? You don't need that. The only reason why now we are going to the court and saying you're subpoenaing Jean Mensah is because of say
Asempa FM.
You close your case. So to be able to subpoena her, and what I will cost for the court, so not court in the mouth.
Emma will sign be a case in the
That is the only reason why we are going to the court. And that's how the subpoena there. You don't need even the leave of the court before you can subpoena a public officer. The subpoena training and say, ye dear assemble courts. Assemble na ye dino, ebia efa. Say obi etua ne tax and obi ntua ne tax ho. So na etinye na koso wo court say ebia Commissioner General for Ghana Revenue Authority ono na adwumayoku a omojeje tax oda no a wonim bi wo mu nyina di watua ne tax ntua ndi bia etinye ya duru ye behia say public officer no obepa court na wabedi adanse na tinya boa ama court no ehu no kra bi a e wa asebi ndi no de wo party a wo free say public officer na wo so bi di adanse the wo friend of ko say be di adanse na wo say memma utimi supina ne say wo mra na wo say wo ba
are you by this argument as Sammy saying sir nyame ya dom na se court no emma mo leave to reopen your case you will not go before the court again to convince the court why e also mo subpoena and as mo subpoena your friend is Jean Mensah.
No. It's not. In fact, the law doesn't require us to go to the court. And not that no lawyer to check out all kind. Under normal circumstances, we don't need to come to the court for leave before we can subpoena any witness or any public officer.
Okay. Into once the leave is granted
but the only reason why I was in your court or the media court or the court and they say okay, Ukulusu case because not unim said Jean Mensah, even the court also knew. And that is why I'm going to free Jean Mensah. Just the near book I say they are even surprised they didn't anticipate this. Into more court, no more dream at the I am running my address. So yes, it based on such change in Abano. Yeah, Konya Kosro, because you European case near European. Now you supini. So now
okay.
And also no parties ne woman near Yadri, and almost one market into your money and Yadri, not court tonight. But may Obi, in all this, you see, what I am happy about, and I say, Ghana for him, Oh yeah, yeah, but radio so be kasa say no.
Ekosiisen on
even lawyers they work court omu gina omu na so omu kasa. If work school omu ni mumra omu nim de. But Ghana for so nim di obi wa on ko school. But when you many penyansa, they can see things, they can watch things and make a decision on their own. So sometimes ubetinya ko court. If you are there kwa ukosre court no on sanka. But at the end of the day, majority of the people may agree with you, say, what's the more working yet? The battle is not over. We are not discouraged at all by this ruling. And there was say a family kwansu yibian yebeye. Ruling na yefi say bibia chia wom e wo mramu ni die mu ene mra kwanso no yebehwe kwan ya yebetumi afa so akwa akosere court ne so mo say so ma through a review application.
Okay.
I say no anye yimpo a that notwithstanding we still have the right say yebe back court na nim say omo my kwan ya reopen case na afidie ye mum yemfre Jimensa as a public officer, not a party to the case. No media dance here mayen, not the issue. But a dance here now over media mayeno or basa ye thankful. But to be dia dance here mayen, you know your friend hostile or access witness. And it is straight, legal knowledge. This is provided for in law. And
so I get that point. But Sammy said yeah, what can I say Sisiano or back quarter or bar as a hostile witness into more like or more adversary and or say ababema witness at the amamu. How do you expect that to play out? It is a obema evidence for you to hit her with the evidence or the mamono.
So oba asem na oba beka ni nyina no waba one of our friends say we dance in you. Asem oba beka ni nyina no so no oba beka de tia wo case. I don't think your friend who star witness. It oba but there are rules on hostile witnesses and how the court treats the evidence of a hostile witness.
It obeka de tia case there na ofre na yeden.
No. Na say obetumi ababeka de ope but it is cross examination. So certain things can be confronted with you. Untimi deny and I would deny krana and maybe will be put to you or suggested to you. It will go into evidence. So there's yeah. And maybe so you can put where or suggest where or better to even though she's a hostile witness because the evidence may be compelling or that question or logical reasoning maybe or legal reasoning may be compelling. So lawyers are trained on how to handle hostile witness.
To handle hostile witness.
It's a whole chapter in the law of evidence. So we lawyer Chatuchikata, is a colossus when it comes to this.
But again, it comes back to the point, and I think now a obiter be in the end ruling, and the court made it clear, say, a petitioner wins a case in court on the strength of... I don't think it was
even the obiter. I think it was...
was it a ratio? I don't think so.
We were costing Justice Ofayadinyira in the 2013 election petition.
Yeah, but relative to any ruling, was it a ratio? No,
it should be ratio. They were... Okay, well, whether ratio
or obiter, no, it's in there.
Yeah.
No, when that point has been made by the highest court of the land,
it's got nothing to do with the subpoena.
No, but I understand.
Case, let's look at the
Sammy.
Hold on.
No, Mami, the American say, Sisi no more friend about as a hostile witness, and you believe, sir, or maybe I have some commitment, me admissions be a beboa mo case, Is that not to suggest then, sir? Because to go through all this pain to get her to come, means, sir, you've not really established a solid case as at now.
It's not about that. Say Namdodo and Zemkwai, Obi. Namdodo Zemkwai. And you see, it's not only about establishing your case and getting victory or defeat in court. It's not just about that. Yet Yehuni says it's not just about that. In Penuphobia, almost some of mine will know was almost as your minor son for. Almost ye Juma Magana for. He said, we ye Juma, we in year and one. And what would need new Buma Ghana for now be Bumaconta? If for nothing at all, even if her evidence will not add anything to her case, the need to hold her account on Krana enough to bring her into the box. Because Nejuma was a year as returning officer. Oh, yeah, and now
but holding her to account, holding her to account, no, was the court the right forum? And I ask this based on message based on message grandpa asked Menchia South, Kumasi Utie, Osi Obi. Kindly ask lawyer Sammy Gyamfi to explain to Ghanaians the legal authority under which they went to the Supreme Court. Did they go there to challenge the result of the elections or for accountability sake? If it was for accountability, i.e. for Jean Mensa to render account, why did they have to go under the guise of an election petition? Sammy?
You call court to say about to Jean Mensa dia to Ghana. And a Ghana mra kunyi 1992 constitution ni bobra. They will say warene election no eye Omampenye Kufuor no. Pe ono ankasa declaration no ye hwense mu wo mu a warene. Into the validity of the election of Omampenye Kufuor no ye call court to say ye kwa challenge. Yes, Omampenye Kufuor Mensa says he has been validly elected as president of Ghana no, in the 2020 presidential election. No, we disagree. He was not validly elected. Yamfamra kwanso ne to abeyi no, because Emrane say I was saying kunyama papa do no. Total valid votes more than 50%. You heard declaration in Mensa at Yabana wenya. So we are challenging the validity of the election of candidate Kufuor. We are challenging the validity or the constitutionality of Mensa declaration say Omampenye Kufuor. That is it. No two ways about that. But as part of that challenge, when you do challenge, the returning officer, when the returning officer, Mensa. So you challenge the Juma dia. Then in that same vein, it means we are holding her to account. The Juma and Yasu Muhwa Konta. So the two are not mutually exclusive. I don't know why people are trying so hard to separate something. One and the same.
Yeah, maybe because Omuhua Kontano should be according to the procedure. You don't get her to render
2013.
Yes.
According to procedure. No, I want you to finish that question.
Because you don't get her to come into the box to render account on your say so.
Suggesting that subpoena is not legal procedure.
No, so subpoena is a new thing ever. Up until this time, the argument has been say or your constitutional officer was all render account magana for the Supreme Court was clear on that.
One of the arguments, yes. And what is wrong with that?
The Supreme Court was clear on that. Say being a constitutional officer doesn't change the rules of the game.
Supreme Court decision, but we are entitled to have our opinion. And that is the opinion we canvass. Supreme Court money and that is their decision, and their decision is the law. But we are also entitled to disagree with the decision and to apply for a review of the decision.
Okay.
So we are not saying that we have abandoned that. But have we sought to use any other process other than what the law provides to hold her to account? Yeah, they are boy and I ever any mu say na lawyer for be friend na mana be dia dance and na lawyer for so mo friend no mani be dance no mo dey who say who ya kwa so mo friend dance ni dia and I say there because na lawyer for kasa ye ni omonya adwen because they sati asemi Mensa ankasa nu mu asem ne nkrata bi ode ne sa hyehyɛ ase a eda court na nim kyerɛ sɛ ɔno aka so be dia dance na fe de ada na adu so be dia dance a udwane and a court ne say me ne mo nya adwen o wo ho kwan sɛ so kaso ba be dia dance ekro bitimi asesa na adwen se wasesa na adwen a emre bia ni wiase a ye bitimi gina so de ahye ne setin branch a wo be dia dance and ye see you yate ba ye ne court nya adwen ye be kwa kopi so ni a ya sere court ni die mu ne mra mu se o wo bitimi asesa o madwen but no kwan na nkyere no ye wo mra foforo bi wo ha
FM
se electoral commission for e na omo se omo mfreji Mensa na court so say on to me share electoral commission for emom mfreji Mensa so mo dance ni no problem ye wo mra foforo bi wo ha jo mahama ono ye petition no obetimi agina so no de afre Mensa as a public officer say o media dance ye ma ono jo mahama eno ne friend subpoena no oba as an adverse or a hostile witness amra ne ma ho kwansa And the Yagina Samra, so the Akoto court, and then him say, yes, Romo. Or my Aquina, Yanzan, reopen our case because we've closed it. Now, you to me, yes, Adian. Tia ready a court on the back.
Mene will colleague Kojo. Okay, Sammy Mene will colleague Kojo upon Cromadine Commander or draw parallels between the AC this year to what happened in 2013. And he makes the point, in 2013, the petitioners proved with hardcore evidence, a pink sheet, and the drew level be at the EC source. They had no option than to mount that box and defend the work they did. In Mumu case,
was Kojo Ponkroma in the head of Petition and Afarijan?
But Afarijan mounted the box, didn't he?
But so what? But did they tell us the reason why they mounted the box?
Oh, they didn't.
Yeah, Afarijan mounted the box not because he thought the petitioners at the time, Dr. Bawumia and now the Danko Kufuado Jacobiche Bilamte, had made any compelling case for them to answer. Maybe he felt, Mejuma na amount for Totona Sibu and I should come and defend my job. Until Afarijan and Kwashiadan tells us what made them mount the box. Where was Kojo Oponkroma in that equation? For him to tell us the man easy for any lawyer for taking his decision in 2013. He's just speculating. The emphasis. What do you say? Your public officers be briwa. The Omoko courts. Omobetinya hide behind technicalities of the law. No matter say unyam yekis papa bi ntime kwa mekasa. But there are some people they are principled. Omon pese wo modwuma o ma ye ni yi afa mra kwan so obetoto na se na wagu omani mu asa na they say wudi na no aba be yen kaidum ama nchirima. Nti obeba as a public officer, are you ready to be held accountable, to clear his name, defend his work, so that it will be recorded he will be judged well by posterity. I believe that is what Afarijan did. Because about compelling case here, and the 2013 case is so useless.
Hey, case ND 5-4.
You could go to court. I'm talking about some of the issues.
Yeah, but you said case is useless. One cause some of the issues.
Some of the issues they put before the court, for me, were preposterous, ridiculous. To go to court and say, millions of votes, we say, you to abandon you know, you try abandon so go form is you have read the pink sheet. Now, pink sheet in the number B, or more print, you know, or more print, or more the number B go pink sheet in the so. Some numbers, maybe you duplicate serial number, future results. Even this frivolous case, you can and his friends believe in this and they went to court.
Yeah, but there were some issues in there that led the Supreme Court to rule 5-4, and that was close. And it tells you, sir, they proved something to the court.
They proved what? They still lost. They didn't win one on one issue. Even if it was 4.5, 4 krana, they still lost. They didn't win even one issue. So what did they prove? If they didn't win, then they didn't prove anything.
My final question. My final question is, okay.
Obi, say improve your case there. Why wouldn't they file a submission of no case?
Asempa FM.
You improve she court no. You improve she asama yakani ni na so bia na adwoma na aka ne kokan. Eni na so bia, we have not proven anything. Ask Kojo Ponkroma. Why then won't you file a submission of no case? Because that is what you file. When a party comes to court and fails to discharge the burden of proof, and the case now what the no, even if na allegations are why it will not entitle him to any of the relief he's seeking. You file for a submission of no case. And then in this matter, court why are you filing for submission of no case? Obviously, we are not filing for a submission of no case. Meaning there is a case.
So if there is a case to answer,
why then do they come to the media and say, we have not proven any case? If we have not proven any case at the end of we closing our case, then you should file a submission of no case.
No, so if they fail to file a submission of no case, they decide. Hold on, Sammy. They decide, say, enyadia ombe or more witness. Then the petitioner should be extremely happy that you have a strong case. The court is being called upon to judge based on the evidence. The legal
effect is different. And every lawyer understands that.
Mm-hmm.
Because the workers will be proven the case. Now file a submission of no case. Not only are you not going to be calling witnesses to give evidence to support your case.
Ekosiisen on Asempa
But
FM.
nipa ne de na Asempa court no. In this case, petition na file no. Say almost the answer by pleading. So no ye by. Sa no ye no court no be want to atwene. Ni aka say. Say what's in the pan in the case dia anyone no ye no kra hia yem fa ntonche. Ni ehwe nipa na asem no kwa. Ni ehwe so case and no case. But so one file a submission of no case there, then it means there is a case to answer. You don't think that you need to lead evidence to defend yourself, but you'll be relying on your pleadings, your answer, and also the cross-examination. Why anyone maybe I would go into evidence to fight the case. So that is the difference. So it means say there is a case to answer, but you think say you can defend, you can mount sufficient defense for yourself without calling a witness. But that is not to say without mounting a defense, because we'll answer now filing and you'll be relying on it. And of course, examination, whatever evidence you solicited, you'll be relying on it. Definitely, this cannot be a case. Those respondents are into the media to say that there is no case to answer.
But in civil trial, per practice, in civil trial, ultimately a file an application of no case.
Submission of no case.
Okay. The other thing will be, sir,
under some circumstances, yeah.
Come again.
Under special circumstances, you can.
Ubetima file for no case in a civil trial.
There are authorities to that effect.
And such circumstances now, are they in this particular case?
Yeah, now lawyer Kotoampa argument or comment on submission of no case. And I mean, he says in their opinion, you can file a submission of no case in a civil matter. Lawyer Kotoampa said it. Go and try and read the arguments on this particular objection. Okay.
But the other thing is what are the ramifications for filing a submission of no case? Why do you want to tell them so more? And this
is for the case. I was saying, moment they be prove case. Prove she. For tickets beyond my court. Carry BBR. In any case, if you are there, any file a submission for no case. It's as simple as that.
They chose not to let their witness.
Then it means that they are lying to you in the media. You should tell them that if you think they have no case, why didn't you file for a submission of no case? That is what you should ask them. So if you didn't file for a submission of no case, then it means you yourself, you admit that there is a case to answer. That is why you could not gather the balls to file for a submission of no case.
But how about the choice? Yes, who say muni case it doesn't warrant us to strengthen our case by calling our witness. Until let the court decide on evidence.
May say if we don't have any case, why wouldn't you file for a submission for no?
Another choice. The other choice is not to call their witness.
The two are not the same.
I know they are not the same.
For no case, it means that the person doesn't have a case at all. I know I'm explaining it. The attorney said. The next time I can in a Jitu Mukrumbo say no cry. The also court on the Yamano. Be anyone, I was a court on the Yamano. That is the meaning of submission of no case.
Some the final.
What you prove say. See where no submission of no case. I say petition no only case. Now you be say I went to be anye. We say nye submission of no case. But I was a friend and see ni bako. But men friend no. Into case in Yantuaso. That's what they have said.
My final question is
we don't have a case.
Okay, my final question and it's
legal strategy. And like I told you when I came to your studio on Monday, meaning say we choose our strategy because of Musru. Or would say Jimen's are better than anymore. Their defense will collapse because in Sembisa, you may be said Jimen's and the man no queer one same we appear. So man Pina Kufuado or any other way. And they are rather protecting
as part of their legal strategy, no?
That's what they are. Yes, as part of their legal strategy.
Good.
The legal strategy, Papa.
Yeah, Papa.
When you're born here, we
now, how? Which strategy? Strategy, Ben and Quebec, Papa.
The OBGMs are unfair.
So, my final question, and it says, see, more indicating some of the file as I'm apply subpoena and the Achema Menabano. second respondent in so indicated say eba ne sade na mo bie floodgate no say ansha omo so will compel they would compel the petitioner to come.
One has stop you omo nya ni ya omo twedi. They will have to defend why your mama should be subpoenaed. They are subpoenaing as what? Your mama or your public officer? We declare results.
On your public officer, you said?
Not your mama or your public officer. Your mama is not a public officer.
He's a former president paid by the taxpayer.
Former president, a public officer. Well,
paid by the taxpayer, Sammy.
No, but is it so? The office he holds is what? Former president.
Office of the former president.
Well, that can be debated.
Absolutely.
I don't really know whether a former president is a public officer, but if you say so, they are entitled to also subpoena him.
Okay.
So they can subpoena him as their witness. Because your mama on your bonibia. So if they are able to justify that your mama can be subpoenaed in law, the court should grant it to them. Your mama is not a coward. Your mama will be a bum. Your mama or canocre. Your mama on your bonibia and on any day. You say you'll be friendly bia or beba.
Okay.
Mamia, yeah, train a bossona, they say.
Your friend is Jean Mensa. Your friend is Jean Mensa.
Began about penny Jean Mensa, Electoral Commission ban of Denny. Maybe Mr. Daronum be beside and then some more money being running away.
Mami Musa, Obia Chemagin CBB so say the petitioners now ab initio file a preliminary objection say this whole petitioners respondents no so this whole petition and Casano in disclose any reasonable cause of action no case no more file from day one
no you see what the catcher on your lawyer
on your lawyer
not fair Obi a preliminary objection and a submission of no case are not the same.
No, I mean, can't say the same. I don't think he's saying the same. But the principle.
File a preliminary objection. Even if judgment on that preliminary objection is deferred, ruling on that preliminary objection is deferred until judgment, like Supreme Court ISA.
Yes.
What's the case? The threshold of an election petition. By idea, we announce that notwithstanding, no, the court no na petition no opinion case, exclusion case. You can still do an application for submission of no case. You can still do it. You can still do it. Apart from because the preliminary objection is about saying this is not an election petition properly so called. That is the argument. Which argument I think is bankrupt. But and I mean they are entitled to do.
But would that preliminary objection not even be more serious than a submission of no case? Because I don't know the whole petition or say and disclose any reasonable cause of action.
Yeah, defer judgment on that. But I no say near opinion case near evidence near the bebano. It doesn't even support any of the reliefs we are seeking. Case near frivolous to be in your submission for no case or a submission of no case. Make me first stay or no. Your submission of no case. Not only does the petition fail the threshold of an election petition, but in your opinion, your evidence are the other courts. Say any the dance no. Say court to it will not entitle us to our release. That is a submission of no case. It's different from a preliminary. The preliminary objection, the court will not even take evidence. The court will just decide the matter based on the legal submission. And that is what the court will do on issue 1, which is about the preliminary objection. So what is the difference? And immediate, the Mekacha NDC for Mutie and Ghana for Mutie or Mopeso Mumu Assembly or court team in Ghana, and more Biabamu. Ghana, I am mine. And Yenaya to me, they can be make it in the year. I was here, Samra, so not the any Bibiano, you Sumra. Some of the decisions will be very unpleasant. Some of the decisions, but let's be calm because you are loyal for our and let's continue to pray for them and support them. Now, meaning said, regardless of what the decision of the court will be in this matter, Ghanaians who are discerning will know the truth for themselves and the truth will set all of us free. But that's it.
Lawyer Sammy Gyamfi and Yatene Nkano, National Communications Officer of the NDC, and he spoke in his capacity as one of the spokespersons for the legal team of the